Yes, Mr. Bullman, I'm very sorry to have kept you. That's entirely my fault.
The third principle that I would like to rely on in terms of general construction of contracts, and in particular insurance contracts, from Lewison is the one that begins at page 271 of the authorities bundle, namely that if there is doubt about the meaning of a contract, the word will be construed against the person who puts it forward. I rely in particular on comments in paragraph 774, that this applies particularly to insurance contracts. There's then a number of references and examples of it applying to insurance contracts, various cases, and there's also a reference to paragraph 787 on page 287 to this principle being applied by the Court of Appeal in a case called Pratt Agerjan Insurance, interpreting a warranty given in an insurance policy. So these are basic principles.
I think it would probably be fair to say that in all the years I've been doing this, I haven't yet had a case which I've decided on the basis of contra proferentum. I mean, I appreciate it's a maxim of huge antiquity and all the rest of it. It doesn't tend to be the decisive penalty shootout, in my experience.
No, it rarely
but there's always a first time.
I entirely accept that, my lord. I entirely accept that. However, when one's construing a condition precedent in an insurance policy, which states that the insurer will have no liability if the circumstances then described prevail, then obviously one is looking at that quite carefully to ensure that whatever complaint is made falls within the four corners of that particular clause. I don't put it any higher than that.
Because we're only 150 years after the Master of the Rolls said that it was doubtful.
Yeah.
See, I'm at the cutting edge.
So with that, could I ask you to turn to the core bundle and the policy itself?
Yeah.
Begin at page 128. My learned friend's shown you the first couple of pages of that. I have nothing to add, but I would come back on his description of the general definition of liability conditions for warehouse keepers at the bottom of page 131, which he described as the scope of cover. Now, this point that my learned friend was advancing wasn't considered by the judge. There's no finding of that in the judgment. It doesn't form part of the grounds of appeal or the permission that the court gave for this appeal. And I would submit that if that submission were correct, if it were open to my learned friend and correct.
Which submission, sorry? The
submission that the scope of the policy only covers FDSF conditions.
Yeah.
So that if you're not trading on those conditions, then there's nothing.
I didn't hear him to say that.
Ah,
I think it only covers such conditions as have been approved by the underwriters in writing.
Yes, yes.
Do you take issue with that?
Well, I do, because then my learned friend then equates that with what's on page 128.
Yeah.
The reference to the trading conditions of FDF.
Yeah.
And indeed he makes the same submission throughout when considering the scope of the duty of assured clause to equate FSDF terms conditions with all the different descriptions of the clauses that are set out in that condition precedent. And I say that the terms of the policy are not limited in the way that the learned friend says. If that was the case, you wouldn't need the conditions precedent at all. You would simply have a term stating that the insurers will only indemnify the insured for liability under the terms of the FSDF contract, or under the terms of FSDF contracts, I should say. So in my submission, that's not either open to my learned friend, nor is it the way in which the case was argued below or in the grounds of appeal. And it would be extremely surprising if that was the case, because it would effectively render the arguments below and the rest of the arguments before this court redundant.
I understood his argument to be he's relying on the conditions precedent but
Yeah.
saying that in construing those, one has to have regard to what he referred to as the scope of cover
Yes.
provision.
Yes.
That can't be objectionable, can it? In terms
Well,
of,
no,
you've got to read the
not
contract as a
put
whole.
in those terms. Not in,
Yes.
put in those terms.
And on
But-
that, do you disagree with his interpretation of the scope of
I
other
do.
clause? Yes.
Yeah,
Well, how-
his
what do you-
submission to the court was that the words "as may be approved"
Yeah.
are in fact applicable to every reference there to the 5 different types of conditions, both the NAWK, the UKWA, the Road Haulage Association, the own trading conditions, as well as other conditions. My submission to the court is that those words "as may be approved" and by underwriters in writing only refer to the other conditions.
Yeah, in other words, the part that comes after and or.
And those words "and or" separate
Yeah.
repeatedly all the different conditions that are then referred to.
Yeah, so we read other conditions as may be approved by underwriters in writing as
Yeah.
its own separate self-contained clause,
Exactly.
and we don't split off the words as suggested by the
Indeed.
appellant.
And that's an important part, I submit, of the
Does
background.
it make any difference though whether it's done that way or not on this particular case?
Well,
Because there's no evidence that any other of DNS's conditions were approved in writing.
that's true. But there is evidence that DNS were trading under more than one set of conditions.
Understood. So it makes a difference in construing the policy, but it might not make a difference on the particular facts.
That may be.
Understood.
But in my submission, that is part of the background against which one does then come to construe the condition precedent, because indeed, as my Lord Justice Coulson recognised in the permission that was granted, if I could just show my Lords that, page 23 in paragraph 2A, in the middle of the paragraph, after the word "firstly," 4 lines down, sentence beginning, in a case concerning non-consumer contracts for food storage, in an industry where there are numerous sets of trading terms to which such contracts can be subject, it is plain that the trading terms under which the insured seeks to engage customers are a key detail that forms part of the presentation of risk.
Where are you reading from?
So that's from paragraph 2A of the permission.
Yeah, of the permission.
So we have a background when one comes to construe the duty of assured case, whereby the assured, DNS, could be trading on one or more of numerous conditions. And so the purpose of the clause is to require the assured to identify which of those or others he's actually trading under. That's the first point of the clause. If I could then go to that, page 136. As my own friend pointed out, it's within the general conditions, exclusion, observances section of the policy, and it describes what is, in the singular, a condition precedent to the liability of underwriters, and then there are 5 numbered subclauses. 1 to 3 all concern the trading conditions under which the assured is operating. 4 concerns the provision of information, and if there's any incorrect information recklessly or knowingly or deliberately furnished at any time, then that would be a breach of the condition precedent, that subclause thereof. And then finally, at 5, if the assured at any time acts without due diligence, then that would also be a breach. So we have a potentially very wide clause here that we're dealing with. The last 2 subclauses don't relate to trading conditions, but the previous 3 do. And the last words, subject to and incorporate the provisions of the Insurance Act, really just recognise that this insurance policy must be subject to the law that applies to it. They really goes no further than that. It was during the course of my research that I found this reference to LMA 5264 and the clause which you now see at page 141, and just because it was referred to, I thought it should be in the court bundle, so I asked for it to be put in the bundle. And really, this doesn't do anything other than just confirm what is obvious, namely that whatever the duty of assured clause might say, it's subject to the Act. And the point that my learned friend was making submissions on about, the difference between it being incorporated or not incorporated, in my submission, just go nowhere. Because the Act either applies because it applies as a matter of law, or it applies because it then qualifies the terms of the condition precedent that precede it. So if they can't disclaim under the Act, they can't disclaim under the contract either. It's as simple as that. So subclause 1, as my learned friend accepted, although that was the subject of argument below and in the grounds of appeal, requires the assured to make a declaration of all current trading conditions at inception of the policy. The declaration is a representation made by the assured to the insurer, and it's not restricted to their conditions. It's not restricted to standard conditions. It anticipates that the assured might be trading under more than one set of conditions. That's what all refers to. And the word current recognises also that some terms may no longer be applicable. So it may have been the case here that UKTA terms didn't apply at all to DNS. What it's targeting is a declaration of all of the different terms that are being traded under at a very specific point in time, namely at inception of the policy. Inception of the policy, of course, go back to page 128, is 0-100 hours on the 30th of June 2019. So as my learned friend, I think, submitted, the purpose is to enable the insurer to understand the risk that he's taking on, so he can decide whether and on what terms and on what premium he's going to contract. And we say that this declaration is central to a proper understanding of this clause, of the first three paragraphs, subclauses. And everything that follows in 2 and 3 must be seen in that context. I think below it was submitted to the court that 1 was really irrelevant. It's not irrelevant, and there's an important link between 1 and 2, seen by the word declaration or declared, because the same word appears in subclause 2. Subclause 2 reads, during the currency of the policy, the assured continuously trades under the conditions declared and approved by underwriters in writing. So first of all, the currency of the policy is, again, we go back to page 128, from 0 or immediately after 0-100 hours on the 30th of June to the 29th of June 2020 at 23:59 hours. The word continuously is an adverb that means without any interruption. It does not mean only or exclusively, suggested by my learned friend. If that had been intended, that word would have been used. It's deliberate in my submission in not using that word. And the word declared ties it to the declaration that's been made under 1. So absent any declared conditions, subclause 2 doesn't run at all. And the purpose of this clause in Scotbeef's submission is to ensure that the declared conditions, whatever they may be and however many they may be, stay the same through the life of the policy. And this obligation commences 1 second after inception, and it lasts throughout the period. And like 1, it's dealing with trading conditions in general. It's not tied to the specific conditions referred to on page 128. It would have been easy to do that if that's what it intended. It's a general clause that applies to what is and tied to what is declared under 1. So we submit that that Lonham is wrong to say in the skeleton argument, paragraph 41, that 1 and 2 are addressing different subject matter. They're not. They're both concerned with trading conditions in general. The difference between them is that they're targeting different times. 1 is just targeting point of inception, and 2 is targeting the period of the policy. Equally, we submit that Lonham is wrong to suggest in paragraph 43A of this appellant skeleton that a breach of 1 does not entail or necessarily entail a breach of 2. It follows, we say, as night follows day, that if you fail to make a full declaration under 1, you will then be in breach under 2. And that's exactly what's happened in this case.
Right, you're going to have to help me with that. You might have let's call them Company X. You might not have any trading relationship with Company X at all at the inception of the policy. And you might not be in breach of declaring your current trading conditions at the inception of the policy.
Yes.
You then, 6 months later, start a trading relationship with Company X who say, we don't like your current trading conditions, here are your others. Here are ours, or here are some bespoke ones,
yes,
for a completely different set. And DNS decide, very attractive business, yes, we'll contract with you on that basis. They'll be in breach of 2, but they won't be in breach of 1.
I accept that. No, I accept that.
So
they don't get approval.
There must be exactly. So there must be situations where you could be in breach of 1, but not in breach of the other.
No, I don't accept that. I accept that you could be
in breach
of 2 and not in breach of 1, but I don't accept the other way around. Because if you are in breach of 1, as was the case here, you must, 1 second after the policy is incepted, be in breach of 2. It follows.
Right, so sequentially you can be in breach of 2 and not of 1, but
Yep.
if you're in breach of 1, by definition you'll be in breach of 2.
And it's completely unreal in my submission, that Lonham's case, which suggests that it all depends what you do after the policy. It's all about conduct after the policy, whereas there's this clear distinction between a representation and conduct under 2. That's just not real in the context of this relationship.
But isn't that an automatic function of the fact that 1 deals with your existing trade, your existing contracts at inception of the policy, and 2 deals with your future conduct or your future trading, doesn't it?
Well, in my submission, they both deal, there isn't a clear distinction along those lines. They both deal with terms under which the company, DNS, is operating, the insured is operating. It's, if one looks at the wording, when one reads it at first, too, you've got to be continuously trading. And that's not a proper way to interpret this clause. It's not imposing an obligation to trade on the assured. What it's targeting is that the trading has got to be on the conditions declared and approved. That's what it's targeting. So it's a state of affairs rather than an obligation to actually do something positive. And it's that word declared which ties the 2 things together, means that they must be dealing with the same thing. Again,
Do you dispute, though, if the conditions that you're trading on don't fall within the clause at page 131, scope of cover clause,
yes.
then it won't be cover. You dispute the meaning of that clause, but it's quite possible that you'll be trading on terms that are not NORC, not Aqua, not Road Haulage Association, not your own trading conditions, and nothing else approved. In those circumstances, is there cover, irrespective of 1, 2, and 3?
So going back to that earlier point, my own friends accepted that under the terms of this clause, you could be trading on terms which were not covered by the scope of duty clause, which would then still be nonetheless covered by the insurance policy. So
Sorry, say it again.
namely, he accepted that when you look at the proviso of 3,
Oh yes, there's an expansion of.
there's an expansion.
You have to get within 3 for that. Yeah.
Well, yes, but I would submit that if there is such an expansion under the proviso, then there could equally be an expansion under any of the other clauses as well. Because what one is doing is requiring you to identify all your current trading conditions. Now, it's a neat point whether that's, and to what extent that is covered by the words own trading conditions or other conditions as may be approved. I accept that they might not be covered by the earlier wording. But there could be other clauses. For example, even within subclause 3 itself, if I ask you to look, my lord, at the second bullet point of that second example, there's a reference to beefer. Now that's not covered by any of the scope of clause, of cover clause, but nonetheless it's referred to. So in my submission, the duty of assured clause does anticipate that there may be clauses under which you're trading which are not covered by the earlier clause on page 1. And that's why it's of central importance to this case rather than the general scope. The general scope of cover does identify a number of possibilities, and that's the background against which one should interpret the duty of assured clause, but it doesn't restrict it entirely for the reasons both that I say and my learned friend accepts. So there is therefore in my submission a natural connection between 1 and 2, which rests on, importantly, the word declared, and not on a reference back to FSDF or any other particular conditions. And therefore, I don't accept that there's this neat distinction between a representation and a warranty in this case. The two things really are just the same, the same thing, but at different times. And then moving to subclause 3. Now, my learned friend said, before I deal with it, that subclause 2 requires any new contracts to be only on FSDF terms and any existing contracts to be put on FSDF terms. Now, that's exactly the same submission that he makes about 3. Which, of course, leads one to conclude that they can't be targeting the same thing. What would be the point of having 2 separate clauses that say the same thing? I point out to the rules that the word continuously is used into very deliberately. It doesn't say only, and it doesn't say exclusively, as suggested by Lonham. Those import quite different obligations with very different results. And my learned friend's submissions all proceed on that premise, that 2 means that you only trade on the declared terms. In my submission, that's not correct. My submission is that 2 targets the same contracts as 1 does. So it's the existing contracts at the time when of policy inception. And what it does is it stops the assured from changing those conditions without the approval of the underwriters. So we know that in this case, DNS traded until some point in 2016 on UKWA terms. It then gave the notice that my own friend showed my lords, page 169, notifying the Lonham that they had changed their clauses, and that was accepted by the insurance company. That's something that can happen, and so therefore there was no breach. If it was the case that DNS had not obtained the insurer's approval, then there might have been a breach of 2. That's what 2 is targeting in my submission. not, as it were, an exclusive use of the conditions identified under 1.
If they were targeting the same contracts, then 1 is dealing with all current trading conditions, and there's the declaration. Then 2 is contingency trades under the conditions declared, and you've made the submission about that link. But then, and approved by underwriters in writing. If it were the same contract, you wouldn't need that. Don't those words presuppose that there may be new contracts, and so those terms would have to be approved? There's an additional condition approved by the underwriters in writing.
Yes, I do accept that. I do accept that. But it's possible that 2 would apply not only to existing contracts but future contracts, as I did a few moments ago as well. But my point is that what 2 is doing, it covers the existing contracts, but what 2 is doing is that it is stopping the insured from entering into contracts that don't comply with what is declared under 1. Yeah. They're not the same thing.
Why is that? Because you say continuously doesn't mean only.
Yes.
What's to stop the assured end? So it declares 1 set of terms, FSDF.
Yeah.
And the next day or next week it enters into a new contract on some completely different terms. That's not a breach of 1. It's not a breach of 2 on your case.
That's right.
Because the obligation was only to continuously trade under the contracts that were already trading under those conditions at the outset.
Yes.
Yeah.
That's why we've got 3 in my submission. That's what 3 is targeting.
Right.
3 is targeting new contracts. And it's dealing specifically with contracts as opposed to the conditions that are declared. 1 and 2, therefore, operate together, and 3 operates on new contracts. So looking at it, in my submission, and going back, tying this into the respondent's notice, 2 is subordinate to 1 because they both operate on the declaration that's made at the inception of policy.
Now, that's an expression you use in your respondent's notice.
Yes.
I'm not sure I understood it when I read it in the respondent's notice, and I know I don't understand it now. What
Right.
do you mean subordinate?
Well, I say it depends on the declaration that's made under 1. It doesn't go any further than that. The Lonham submits that 2 operates entirely independently from 1, and that a breach of 1 doesn't matter for the other one. And that's the basis on which it then draws the distinction between a representation and a warranty. I say no, that's wrong. That 2 can only operate if there's a declaration in accordance with 1.
And only on the contracts that were in existence at the outset, you say?
Yes, because those are the ones that are identified in the declaration.
Right. Well, what's declared as current trading conditions, not the actual contracts.
No, that's absolutely right. Yes.
Yeah.
Absolutely right. So, in response to 1, DNS could have identified a number of different conditions, including specifically here the contract that was made with Scotbeef and the particular general services agreement, which we have in the policy in the bundle as well, which you may have seen at page 170 bundle, which is not on FSDF terms. It doesn't mention FSDF terms. Could have done that. If it had done that, then there could be no question of any breach of 1, and we say there could be no question of any breach of 2 or 3 either. So the mischief here is in failing to declare that the existence of the GWA at the inception of the policy.
GWA being your shorthand for
the general, GSA, probably a better way, but which which is page
February
117.
17.
General Services Agreement,
Yeah.
yes.
Which is the February 17.
That's the, I think it's January.
Sorry, the
19.
2017.
January, that's, no, there was
Oh,
no
sorry,
written
the January
agreement.
19. Yeah.
There was no written agreement.
I'm so sorry. Yeah, you're right. Yeah.
So then turning to subclause 3, this requires the assured to take reasonable and practical steps to ensure that what's described as their trading conditions are incorporated into all contracts entered into by the assured. Those words entered into by the assured, we rely upon particularly, so they're important. Now, that is clearly a different obligation, I submit, from the obligation in 2, however one construes 2. First of all, the all reasonable and practical steps that are referred to in the first line are not what you might describe as the absolute obligation, which is referred to in subclause 2. Their trading conditions are not the same either as all current trading conditions referred to in 1, or the conditions declared and approved referred to in 2. And the operative words, shall take, are forward-facing. They're not concerned with past acts, as the judge found in paragraph 75 of the judgment. Any failure to take reasonable practical steps prior to the policy would not be relevant. This is forward-facing. Similarly, we say the reference to contracts, all contracts entered into by the assured, we say that is forward-facing as well. So in other words, dealing with new contracts. If that were not so, the words entered into by the assured would be surplusage.
So their trading conditions means what? It doesn't mean what appears in 1 or 2. What does it mean?
Yes. I'm not sure I know the exact answer to the question. It's not the same thing. No, it's not the same thing. One has an illustration of what it means in the second bullet point. If own conditions are used, i.e. not industry standard conditions such as BFA or RHA, a copy of those conditions should be made available to the insured customers at the time of contracting.
Well, that shows it can include something referred to as own conditions or industry standards.
Exactly.
Either.
Exactly. Now, what I would submit is targeting is the terms, and there could be more than one set of terms here, under which the assured DNS generally trades or is trading throughout the policy. That's what I submit.
So I say it again.
It's targeting the terms and conditions that DNS offers to trade under during the course of the policy.
Offers to counterparties, not to the insurer.
Yes, absolutely. Oh yes, to customers. Their trading conditions.
But if that's right, and it does do those things, it is all forward-facing, and it's relating to their future activity, future trading activity,
Yes, I accept.
or new contracts.
Absolutely, new contracts.
Isn't it a future warranty?
Not if you're with my own friend on the construction of this.
Well, forget who I'm with. I just mean in generalist terms,
Yes.
and the
It is a
classification.
future, on its as it stands on its own, it is a future warranty.
Right.
And I submit that it's not targeting existing contracts, and if it was targeting existing contracts, it would be putting a potentially enormous burden on the assured to try and vary the terms of those contracts. And that would be very surprising, in my submission, for an insurance company to try and require an insured to change the terms of its contracts from, and that would apply to any contracts that were not on their trading conditions. So if D&S were trading on other parties' conditions, because there'd been an exchange of emails or a contractual agreement requiring them to trade on different conditions, they would then, notwithstanding that that had already been agreed, they would have to try and go back and change that agreement. And that's unreal in my submission.
Well, that's the new contract point that was explored this morning, isn't it?
Yes, indeed.
And the third bullet point, as a matter of law, you can change the conditions on your subsequent invoices as much as you like, but a court would say, well, you have to look at the contract at the time it was made,
Exactly.
when you put your invoices in 3 months later.
Absolutely.
I mean, it's a sort of shorthand guide to how to win the battle of the forms.
Exactly.
But you need the first point first. You need to quote your own terms and conditions first. And that, as my Lord says, was the point of my question to Mr. Buckingham earlier this morning.
Precisely. Right,
Yeah.
Precisely.
But without jumping ahead too much, Mr. Boardman, is it therefore the case that the different issues that we've got to consider today could lead to a situation where the date of the contract becomes of critical importance to answer the stark preliminary issue about whether there's a right of indemnity?
It could be. It could be of importance. Yes, my Lord. I mean, the question that you raised. I mean, it had never been argued that the contract that we were dealing with did not precede the insurance policy. That's been the basis on which both judgments have proceeded. Though yes, it's true. My learned friend is correct to say that in the particulars of claim there was a reference to possibly not being a contractual obligation, but that's not the basis on which the judgment proceeds. That they are contractual arrangements originally on very, very sparse terms and then supplemented by the 2019 written agreement in the way that you have seen. And so I don't think either of us are suggesting that there is no contract or that the contract was made after the date of the inception of this policy. So I'd invite you to proceed on that basis. So far, we've looked at the body, as it were, of the operative part of Clause 3. There are then some examples, as my learned friend called them, of really just subjective views of the assured. They're not requirements. It was suggested in the skeleton argument, Lonham, that these were actual contractual requirements. They're not, but they're simply steps that the underwriters consider to be reasonable. But of course, that is very fact-specific. As my Lord Justice Coulson put to my learned friend, it very much depends on at what stage you are and whether or not you're dealing with what type of contract you're dealing with. As regards the first bullet point, we know that in this case, what was agreed right from the outset was the pallet price. There wouldn't need to be any quotations, therefore, but I accept the point that was put to my friend, the reference to quotations must refer to contracts which have yet to be made. In relation to the next bullet point, this would only apply if the assured is not trading under industry standard conditions. So it wouldn't potentially apply in this case. It's only if own conditions are used, then they need to be made available to the insured's customers at the time of contracting. That is a clear reference, we say, to targeting new contracts. And then finally, there's a reference to the invoices, and I accept entirely and endorse, my Lord, respectfully, the point that my Lord Justice Coulson just made to me, that you can put whatever you like on an invoice. It's not going to change the contractual terms. And in this case, we know that it didn't change the contractual terms. That's what the judge found. But stepping back, all of this, in my submission, is targeting new contracts. There's nothing that requires, in the wording of 3, that requires the court to interpret it as applying to pre-existing contracts. And in my submission, the reference to their trading conditions supports a narrow definition rather than a wider one, because it would require on Malone and Friends' interpretation, if it applied to existing contracts, it would require the assured to try and change any contract that wasn't on DNS's own terms from time to time. They might change during the course of the policy. So that might require it to consistently go back to clients, try to renegotiate terms which it had previously agreed to, and that might damage its relations with those clients. That couldn't have been within the contemplation of the parties when they made this policy. It would be a very onerous burden indeed, particularly in the context of a duty of assured clause which states at its outset that this is a condition precedent to the liability of underwriters. We say that the coherent interpretation of this clause requires a distinction to be made between 1 and 2 on the one hand, and 3. 1 and 2 deal with declared conditions, 3 deals with their conditions and relates to new contracts. Otherwise, in my submission, there would be an inconsistency between clauses 2 and 3, the former imposing an absolute obligation, whereas the latter imposing a reasonable and practical steps obligation. The former requiring the assured to continuously use all declared conditions and only those conditions, whereas the latter requiring it to stop trading on everything other than their conditions. The former applying every second that the policy is in existence, the latter applying only naturally at the point when you are making a contract and you have to win the battle of the forms. You cannot, in my submission, have 2 clauses applying to the same contracts but imposing different requirements. And the fact that this would be the case if Malone and Friend was right shows that Lonham's construction is wrong. And Lonham's case that 3 simply qualifies 2 or operates as an exception to 2 is also wrong, because what it does is it requires you to ignore the operative wording of 3, that big paragraph, first paragraph as Malone and Friend described it, and it renders surplus that entire paragraph, because he said 2 meant exactly the same thing as the first paragraph of 3. And that's simply not what 2 or 3 say. And it's very unlikely, in my submission, that the drafters of this policy would have included 2 clauses that meant exactly the same thing. And the reason why that is important is because when we come to the proviso, that is a proviso which, on its wording and indeed on its position within this condition precedent, clearly applies to subclause 3.
Only.
Yes, that's my submission.
Yeah. No, I was just adding that word to be clear, but I knew that's what you...
Yes, and one sees that, it refers to contracts, not general conditions. It refers to failing to incorporate them. That's obviously a reference back to the previous paragraph, first paragraph of paragraph 3, subclause 3. The above mentioned conditions is clearly a reference to their trading conditions. It's not a reference to all current trading conditions or conditions declared and approved in subclause 2. And really all it's doing is saying that if you comply with the first paragraph, it doesn't follow if you're making a claim under a policy which doesn't include those conditions, that your right to an indemnity is taken away. I mean, it really doesn't say more than what would be fairly obvious, because 3 is only a reasonable and practical steps obligation. It doesn't guarantee the outcome. So in summary, Scotbeef submits as follows: that DNS did fail to comply with 1 because it failed to declare the contract with Scotbeef was not on FSDF terms. However, it didn't fail to comply with 2 or 3. It didn't fail to comply with 2 because it did continue to trade on FSDF terms. Malone and Friend took you to our skeleton and said that that was factually wrong, that submission. But it's only factually wrong if he's right on the construction of two, that two means only or exclusively.
Do you mean with Scotbeef when you say it did continuously trade on FSDF terms?
No, I don't.
No, its general business was on FDS.
That's
terms.
right.
Yes.
And that's all that two is required.
And I think that might be, or possibly,
That's the difference
between you on that sentence in your skeleton. Is
Yeah.
that your intent is just a you're intending their general business does still continue on FSDF terms.
That's right. That's what I'm intending. And I submit, therefore, that D&S did comply with subclause 2, and that subclause 2 did not require it to trade exclusively on FSDF terms. It doesn't even mention FSDF terms. And D&S didn't fail to comply with 3 for 2 reasons. Firstly, because it's targeting new contracts, as I've submitted.
Did you say doesn't apply here?
Exactly. And secondly, all the judge found, as I submitted at the outset of my submissions, all the judge found was that D&S had not incorporated the FSDF terms into the relationship with Scotbeef. There's no finding that D&S did not take all reasonable and practical steps. My learned friends attempt to try and bring that in by referring to the pleading, the reply, doesn't work because that is tied to the time of the contract.
That's completely irrelevant, isn't it, on your case, because it doesn't apply because it's not a new contract.
Exactly. Exactly. So those are my submissions on the subclauses 1 to 3. I think you've got my submission, my lords, on the mention of the Insurance Act. Unless there's anything further I can add to that. I don't think I will retain you any longer on that point. The only other clause to refer you to is page 138, the reference there to the effect of a breach of condition precedent. That clause says that the underwriters are entitled to avoid the claim in its entirety.
Where are we on 138?
Sorry, 4th paragraph down, just above the.
Oh yeah, by the first whole bunch.
Yes.
Yeah.
That's not entirely consistent with the opening words of the duty of assured clause, which refers to condition precedent to the liability of an underwriters hereunder. On any basis, this is a very blunt instrument. In other words, it's a far cry from the calibrated remedies that are available to the insurance company under the Act, either for misrepresentation or for breach of warranty. It is an attempt to attain blanket avoidance for any misrepresentation or any breach, however material it might be. And the terms, as I say, of this particular clause are not even consistent with the introductory words of the duty of assured clause. So the end result is far.
I'm not understanding why they're not consistent.
Well, the point is made by my own friend in the skeleton argument of Lonham that the policy does not avoid the liability under the contract. It avoids only the particular claim that's being made. And that's what the clause on page 138 says, or arguably says, because it refers to the claim in its entirety. But in fact, the description on page 136 doesn't refer to that. It uses different words. Well, it's all liability, or the liability of underwriters.
As I read it, it can avoid the claim, that is the particular claim, not the policy.
Yes.
And that's consistent with the opening words, which is a condition precedent to liability. So in the particular claim, there'll be no liability unless these particular CPs were complied with. But it won't avoid the policy more broadly.
Well, it states to the liability of underwriters hereunder. That might mean any liability under any claim, not the specific claim that is then made, albeit that when you maybe that they don't need to rely on it until a claim is made, and then at that point they do rely on it. It's a reference to liability in general that's made in the duty of assured case, and that is something different again, potentially, to the description under the proviso, because on the one hand, page 138, the effect of a breach of a condition precedent is that you're entitled to avoid the claim, but on the other hand, the proviso provides that you will not, provided you comply with subclause 3. So the position is quite uncertain under the terms of the contract. And that's before one brings into account the last words of the duty of assured clause, which then brings in the Insurance Act. And the application of the Insurance Act is not stated or explained, as my Lord Fraser has indicated, Lord Justice Fraser has indicated. The wording at page 141 onwards gives some general description of the effect of the Act. In some parts, attempts to repeat certain parts of it. In other parts, attempts to summarise it. We're left, and this is a clause which has only recently come to light, not a clause that was appended to the policy or otherwise provided to the insured. So the net result is that an assured entering into this policy would have very little understanding of what the effect of a breach of a condition precedent is. And I make that point because, of course, under the transparency requirements, if the clause is not in any way ambiguous, then that leads to non-compliance with those particular requirements. So that's the contract. If I can now turn to the Act itself and its application. If I'm right on the contract, then there's no breach and there's no basis for the insurers to disclaim liability. And to the extent that I'm wrong, and that Lonham is correct on its construction of the duty of assured clause, it's at that point that the court needs to consider whether the Act restricts Lonham's ability to avoid the claim or not. Speaking generally, my lords, the Act does three things. First, it avoids or abolishes the common law right to avoid liability, either for misrepresentation or for a breach of warranty. We see that, my lords, in sections 14.1 and 10.1. I can just briefly take you to those, if I may.
We're going into the Act, yes?
We're going into the Act, yes. So it's the Bundle of Authorities, page 44. And it's subsection 1, which abolishes the common law position in respect of the duty of good faith, so for misrepresentation. And then page 39, section 10.1, subsection 1, abolishes the common law position in respect of warranties. So having abolished the common law, the Act then provides for new, I would describe as calibrated remedies. For breach of the duty of fair presentation, the insurer only has a remedy if it can prove causation. That's under section 3 of the Act. If I could ask the Lords to go to page 32. There's the duty of presentation in section 3, and then at page 35, subsection 1 of section 8, the insurer has a remedy only if the insurer shows that but for the breach, the insurer either would not have entered into the contract or would have done so only on different terms. So it introduces this causation element, as I say.
Which had been markedly absent for some 100 years.
Yes, indeed.
Well, hundreds of years.
And that's reflected in the terms of the condition precedent that we've just been looking at. Because for any breach, however minor, whether related or unrelated, save in respect to the proviso, there is a right to avoid a claim that's made. That's what the subclause.
And even if the breach was remedied before the risk eventuated. Exactly.
And whether material or immaterial.
Yeah.
So in this case, if there had been a contract, not with Scotbeef, but with any other client, on terms that were not within the declaration, then that would have allowed Lonham to disclaim liability on the wording of the contract. And so Section 8 removes that right and requires causation to be proved by the insurer if it wishes to have a remedy. If it can prove causation under subsection 1, then the remedies it has are set out in Schedule 1, that's subsection 2, and that's known as a qualifying breach as set out in subsection 3. And there are two kinds which are then set out in 4 and 5, either deliberate or reckless, or neither deliberate nor reckless. And very briefly, although my lords, I don't think much will turn on it here, and nothing will turn on it here because of the findings of the judge, but at page 52, Schedule 1 sets out the various remedies that are allowed, depending on what would have happened. So the counterfactual that is proved by the insurer. Now, in this case, Lonham attempted to prove a counterfactual, but it didn't succeed. I don't know whether the laws saw that in the judgment. It's in, just pick that up, it's in the bundle. Paragraph 86 of the judgment at page 71, where the learned judge rejects Lonham's case that it wouldn't have entered into the contract on any terms. So in this case, Lonham attempted but failed to prove causation. So that's, forgive me for going back to the public authorities now, so that's the remedies for breach of the duty of fair presentation. In respect of the duty for breach of warranty, or a claim for breach of warranty, the position is governed by section 10. As my own friend showed you, subsection 2, the insurer has no liability up to a certain point, namely before the breach has been remedied, and then there are the 3 qualifications set out in subsection 3. So that's one part of the remedy. But one has to read that also with section 11, which imposes another causation requirement, namely that under subsection 3, if the insured satisfies this if the insured shows that non-compliance with the term could not have increased the risk of loss which actually occurred in the circumstances in which it occurred, then subsection 2 is activated and the insurer may not rely on non-compliance to exclude limit or discharges.
I'm afraid you've lost me again. Which page?
I'm sorry.
Which
page 42, my lord.
On section 11.
Section 11. So under subsection 3, if the insured can satisfy the court that non-compliance, or can show that non-compliance with the term would not have increased the risk of loss which actually occurred, then under subsection 2, the insurer may not rely on non-compliance to exclude limit or discharge its liability. So it's another causation requirement. Now that's the second part of what the Act does. Imposes a new system of calibrated remedies. The third thing that it does is it prevents the parties from avoiding its terms, either by converting a misrepresentation into a warranty, that's section 9, or indeed attempting to contract out of the Act, that's section 16. I can ask you to look at section 9 first, page 37. Subsection 2, a representation may, after reading it, so subsection 1 refers to representations made in connection with a proposed non-consumer insurance contract, relevant wording here. And then subsection 2 provides such a representation, that is to say, one made in connection with the proposed contract, is not capable of being converted into a warranty by means of any provision within the contract. And then in the words in parentheses, whether by declaring the representation to form the basis of the contract or otherwise. The last two words are important because my learned friend, I think, submitted that it was targeting basis of contract clauses, but in fact it's much wider than that. And
Well,
indeed,
well, it was the first key recommendation of the Law Commission report that led to the Act was that breach of basis of contract clauses should be abolished.
right. And what I'm submitting, my lord, I think, is that it goes further than that. It's any term, whether it's by forming the basis of the contract or otherwise. So it's a quite wide ambit. That point,
Possibly future-proofing innovative steps.
indeed, absolutely. And my lord, that point is picked up on, actually, you may find of assistance, by Coulson, page 258, paragraph 8101. Could I invite you to read that? I'm grateful. So I rely on two sentences in particular. One at the first whole punch, beginning, there is nothing in the wording of the legislation, to limit it to confine it to general clauses. That's a reply, if you like, to the load of Fred's submissions and his reference to the notes to the Act. And secondly, the last sentence.
The one that begins, it follows the
effect. Yes, indeed.
Which is based on the first instance decision in this case.
Admittedly,
Yes.
it's based on that decision, yes, of course.
It also
But it
rather
follows.
does this commentary in the text rather sort of elide the main point where it says it will be noted the clauses did not purport to convert the requirement into a warranty, but rather into a condition precedent.
Yes.
I'm not sure that necessarily reflects the proper sophistication of the submissions in this case, because it's the question of whether it's a representation that turns it into a warranty, isn't it?
It is. It's dealing with the point, is there a difference between, my lords will remember, my learned friend took you to a sort of different types of definitions of conditions, page 254, and I think the point is being made by reference potentially to that section before. In other words, it's not just dealing with future warranties, it's also dealing with conditions precedent. Yeah. But in my submission, there is no such fine distinction made by the Act. You did ask my learned friend to address you on the question of what is a warranty for the purposes of the Act. The answer to that, I agree with him, is to be found in the Marine Insurance Act 1906. And the reason for that is that that's incorporated specifically by the terms of the Insurance Act, which you will find.
But there was no part of the argument before the judge of first instance into whether something should be, quote, converted into a condition precedent, because it says it is a condition precedent. The question is what is meant by that.
Yes.
It's not a conversion point at all, is it?
Well,
or am I being overly...
the word conversion in my submission relates to clauses which take a representation that's been made and then put it into a term of the contract.
Correct. Or elevate it to a warranty.
Yes. Yes, and the definition of warranty is very wide.
Yes.
Because it would apply to any type of term, essentially, that does that. I was just going to say, it's clause, section 10.7 at page 40, which incorporates section 33 of the 1906 Act. And then if one looks at the definition of warranty in section 33 of the 1906 Act, on page 8, one sees that there are actually three types. I didn't agree with my own friend when he sought to suggest that there were only two types. There are three types that are referred to here. Namely, first of all, the warranty by which the assured undertakes that some particular thing shall or shall not be done. It's a sort of conduct type of warranty. I think that Lonham was seeking to suggest that subclause 2 was. The second type is, or that some condition shall be fulfilled. So that needn't relate to conduct at all. That's just a state of affairs that exists, and in response to which the warranty would operate. And then thirdly, or where he affirms or negatives the existence of a particular state of facts. So the definition of warranty in the 1906 Act is wider and does not agree with my learned friend's twofold distinction. And that's the relevant one in my submission to apply to the Act. So the consequence of that is that if subclause 2 or subclause 3, or because my learned friend takes them together, because essentially he's submitting they mean the same thing, although they use different words. So he says that if it's about a representation, a promise as to what a particular state of facts is, then it's a representation. But otherwise, it's a warranty, and I don't agree entirely with that submission. But what I submit is that the judge was quite right to find that, first of all, subclause 1 converted a representation into a warranty. She said in her judgment that it was of no effect as a result of that. That's paragraph 73 of the judgment, page 67.
We don't have to worry about that because I didn't give permission to appeal.
No, we don't. Yeah.
I remind you both about what I did give permission to appeal. The submissions stray, rather. Can we just focus on what I did give permission to appeal?
Indeed, my Lord, yes. I submit that 2 and 3 is construed by my learned friend, because he takes them together, says they mean the same thing, seek to achieve the same result but by a different route. Because if, as he contends, 2 obliges A to trade exclusively on declared conditions, and the proviso, or 3, operates as an exception to that obligation, then in my submission the effect of 2 and 3 is to convert the declaration into an ongoing obligation. And that was the sentence that my learned friend picked out of our skeleton. We do make that submission to the Lords.
So the effect of 2 and 3, if he's right, the effect of 2 and 3 converts?
Is to convert the declaration that's made pursuant to subclause 1 into an obligation, which continues through the policy. Because it requires a particular condition to be fulfilled or a particular thing to be done within subsection 33(1) of the 1906 Act. So, in this case, DNS's failure to declare that the Scotbeef contract was not on FSDF terms, that misrepresentation put it immediately in breach of the obligations that the learned friend submits that the assured has under 2 and 3. 1 second later, as night follows day. Didn't require any additional conduct or anything of the sort from the assured. And therefore, that shows that this clear distinction that my learned friend seeks to rely on doesn't exist. And if I'm right about that, and that representation that was made under subclause 1 immediately caused a breach under subclause 2, then section 9 does render the clause of no effect to that extent. And that's really all my learned friend is relying on. He's saying that the declaration was wrong, therefore you didn't comply with 2, therefore I can avoid the policy. I'm saying that's exactly what Section 9 is designed to prevent.
I think he said the declaration was wrong and you failed to comply with 2, not therefore you.
Well, what is he saying that in particular that DNS did or did not do that didn't comply with 2? He can't rely on anything. He's just relying on the fact that they didn't declare the FSDF terms at the outset of the policy. That's it.
Or is he relying on the fact they contracted on terms that were not approved?
Well, that predated the policy.
Well, but I think this is on the assumption he's right on construction, isn't it? Because you say we don't get to 2 at all.
Yeah, well, absolutely.
Yes. So, but if we do get into 2,
Yes.
because it does apply to prior and post contracts,
Yes.
then his case is not there's a breach of 2 because there's a breach of 1. There's a breach of 2 because there's an independent requirement that you carry on throughout the contract, contracting on those conditions.
Absolutely.
Yeah.
Absolutely. But it doesn't require anything other than the existence of a difference between your declaration and the existence of a contract that's not on those terms.
So you say it's because the same facts in this case happen to give rise to the 2 breaches.
It would, as I said earlier, any breach of it's true to say that Malone Friend doesn't put his case by reference to subclause 1. Of course, he just says that there is a state of facts that exists, and that allows me to rely on 2. And I say that state of facts only exists if there is a misdeclaration under 1. If there's no misdeclaration under 1, it follows that there's no breach of 2 because they've been declared. And so therefore there is no difference in this regard between 1 and 2. One follows on to the other, on from the other. And as I say, it didn't require anything else to make good the submission that there was a breach of 2, because it's the same thing that's relied on. And that's what drove, in my submission, the learned judge to accept the submission made to her, that the subclauses must be considered in the light of the duty of fair presentation, because that's actually targeting the mischief and the conduct which is being complained of here. It's not a case, we say, where DNS did anything wrong other than failed to declare that the terms of the Scotbeef policy did not include FSDF terms. And that was something which it didn't do deliberately or knowingly. Indeed, it continued to believe that those terms applied right the way through up to the time of the judgment as found by the judge. And so we say that this clause 2 is just trying to get around the fact that this is a representation being turned into warrant. It's just another way of saying the same thing using different words. Now, if I'm wrong about that, then we have to consider, in my submission, whether or not the clause, the remedy for the breach of this clause falls either under Section 8 or Section 10. Because if I'm right about that, Section 9 renders it of no effect to that extent. And that's in Section 16.1, as my own friend showed you. Then determining that question, whether or not the remedy for breach falls either under Section 8 or Section 10, in my submission, it's important for the court to step back and look at the actual facts of the breach, as I've just been submitting to you, to consider the substance of the breach, and to apply the policy of the Act to it. And that, in my submission, is exactly what the judge did. Here, the facts were a failure to declare the terms of the Scotbeef contract, the substance is a failure of fair presentation, and the policy of the Act is to subject this to Section 8, not to Section 10 of the Act. And that means that under Section 8, the insurer only has a remedy if it can prove causation. Didn't prove causation, as I showed you in the judgment, there's no appeal against that part of the judgment. And so there's no remedy in my submission. If I'm wrong about that, and you find that Section 10 applies to the breach, then I have to deal with the transparency point my own friend relies on. Now, in relation to that, in my submission, the judge rightly held that 2 and 3 put the assured into a worse position than under the Act. To make good that submission, I don't need even to engage with my learned friend's argument about the proviso and whether or not the extent of that proviso, whether it applies to contracts where you have, as it were, managed to incorporate the terms. I can simply refer to the difference between, on the one hand, the conditions precedent, the terms of those conditions precedent, and the terms of the Act. Because, as I was submitting a few moments ago, it's quite clear. The terms of the Act are not the same as the terms of the policy. None of the restrictions that are set out in Section 10 and Section 11 are included within or consistent with the sub-clauses that we've been looking at, and therefore there is clearly a condition here that puts the assured in a worse position. And I would also point out that what my learned friend said about the judge's finding that 3 put the assured in a worse position because the assured was in breach even if the terms were incorporated, and that, in my submission, just simply follows from the very narrow and qualified nature of the proviso. It simply doesn't deal with what happens if the assured doesn't use reasonable and practical steps, but that then somehow the policy is on the terms or on its terms.
But it can't have been intended to refer to that possibility, can it? Because that just makes no sense, does it?
Well, on the face of it, that's what condition subclause 3 says. It says you've got to use reasonable, all reasonable and practicable steps to convert anything into your terms, to incorporate, as it says. In my submission, yes, if you are in breach of those terms, then you're in breach of those terms, even if you actually have a contract which, for whatever reason, despite the fact that you've made no effort to, or haven't used all reasonable efforts to ensure that it is on your terms, it turns out to be on your terms. I mean, I accept that would produce an absurd outcome, but that's no different from the rest of the clause that says that for any breach of the condition precedent, however minor, whether related or otherwise, the insurer can avoid liability.
Well, it is different, isn't it? Because, I mean, aren't we all agreed that that would be an absurd reading, that this is all about trying to get the particular terms and conditions agreed. If they have been agreed through happenstance, there can't be any question of worrying about whether they took reasonable steps.
Well, it's a question of causation. Yes, in a normal claim, because there's no causation between the breach and the outcome, then there wouldn't be a claim. But that's not what this condition says. It just simply obliges you.
I mean, if a court was just looking at that point, it would strive not to find that as the...
I think I probably would accept
the trouble is that's the only reason the judge gives for worse position.
That's true.
Paragraph 80.
No, that's true. I accept that. But as I've just sought to explain, it's obvious in my submission that these conditions do not seek to put the assured, or do put the assured in a worse position, because they simply don't incorporate any of the protections that are set out in Section 11 and Section 10. So in my submission, we do meet that threshold in this case. The clause, if it's to be construed in the way my learned friend suggests, does put the assured in a worse position, and therefore the transparency requirements are satisfied. I think my learned friend fairly accepted that he couldn't challenge the judge's findings on Section 17.
I thought the judge didn't deal with whether there was the transparency aspect was satisfied on this point.
I think it was whether efforts had been taken to draw it. There was no evidence whether efforts had been taken to draw it to the insured's attention.
That's right.
Which is one of the statutory consequences of it being a disadvantageous term.
Yes. So if you've got to comply with both of those under Section 17, you've got to draw it to the assured's attention, and it must be unambiguous. The judge found that there was no evidence put before her of the first thing, so therefore she wasn't satisfied that that was complied with. And in relation to the second thing, she wasn't satisfied that the clause was clear in terms of its effect.
Which clause are we talking about, though? 3.
My learned friend is quite right, and I drew attention to this in my skeleton argument as well, that when one looks at the judgment itself, let me just take you to it, it's paragraph 80 onwards, the judge starts off by looking at, or referring to those subclauses in the plural, but that's after in 79 saying that she's got to consider them together, which is of course the submission that was put to her, and that's what Lonham is still relying on. In other words, that they stand and fall together. And so the judge only directed the point that she made in the second sentence of paragraph 80 to clause 3, and she also did the same thing, and referring to subclause 3 in paragraph 84. But my submission that's in the skeleton argument is that the same thing applies for whether it's relating to subclause 2 or subclause 3. There was no attempt to draw these to the assured's attention, and they're not clear as to their effect, and so therefore the transparency requirements are not met.
Well, she uses transparency requirements plural, doesn't she, as a shorthand, potentially for both the sections.
Yes.
The second part of which has 2 elements to it anyway, which is drawn attention and the clear and ambiguous, and really all we've got that covers subclause 2 is the first sentence of 80, I think, because then all her analysis follows by reference to number 3 only until she gets to, I think, where she just stops dealing with it at the end of 84 and goes back to duty as a sort of a wrap-up conclusion. Really.
Yes, I have to accept that.
All right.
I have to accept that, but I still submit.
I understand
This
your
is the same
position.
point.
I'm just making an observation.
I do accept
on what she said.
And that's what gave rise to the additional ground for the respondent's notice, is that the judge was dealing specifically with 3 in those paragraphs, rather than 2 and 3 together, referring to both of them. Yeah. Okay. So in my submission, even if it's section 10 and the remedies under section 10 that apply rather than under section 8, the transparency requirements are still met, or rather not met, I should say. And so therefore the Act has effect. The consequences of that have effect. And I submit that if one looks at, other than the misrepresentation, if one looks at what is actually the subject of the complaint, so namely the non-compliance that's being complained about here, the non-compliance is not taking steps pursuant to subclause 3 to change the terms of this particular contract. So my learned friend submission is that there were no steps taken, essentially on the back of the findings that he says the judge made. There were no steps taken, save for sending one invoice. And I say, well, in order to advance a case under subclause 3, to say that there were inadequate steps taken by the insured, you've actually got to identify what it is you say they've done wrong. Plus, under section 11, you've got to identify a causative link between the non-compliance and the loss that has actually occurred. Again, we can go back to section 11.2 when I make this submission. Page 42 of the authorities bundle. My submission is that there's no evidence before the court that as to what might have happened or what steps might have been possible. There's no finding by the judge as to.
That's because there's preliminary issues.
That's right.
Parties were very keen on preliminary issues. Obviously, this court often has to say, actually, was that a good idea? you both made points about there being no findings. There hasn't been a trial. So it's rather difficult to, I mean, we certainly can't criticise the judge. She's simply dealing with the preliminary issues that the parties identify. I mean, there's no evidence of anything.
I accept that. But no, nor is there any case, my lord, that this would, if what steps should have been taken, would have resulted in any difference at all. The assumption is made that somehow this would have resulted in the FSDF terms being incorporated, but in fact there's no evidence or basis for that submission. And so there isn't any case for saying that this is a causative loss, and so there's no basis for avoiding liability.
So this point goes to, you say there's an assumption that the FSDS terms would be incorporated, but there's no basis for that assumption.
Indeed. The loan friend submissions equate compliance with subclause 3 with a result incorporating the FSDF terms. But there's no basis for that submission. And therefore he's wrong when he submits that it wouldn't have made any difference, that there is compliance with the Act, because there needs to be a causative link. Even if I'm wrong and this is a warranty, there needs to be a causative link between the alleged breach and the risk that has occurred. And that's simply not shown in this case.
You're focusing just on 3.
Yeah, indeed. Well, I'm doing that, my lord, because learned friend says they mean the same thing. And I'm assuming that I'm wrong on the construction of the contract. I don't, that's not my submission to the court. But that's the learned friend's submission. So I have, if you like, 3 main points. One, on the proper construction of this policy. The insured was not in breach, so therefore there's liability. 2, I'm wrong about that. The judge was right in analysing this as within the duty of fair presentation under Section 3, with the consequence that Section 9 and Section 8 apply. And I've made my submissions as to why they would invalidate reliance on the clause in this case. And if I'm wrong about that, and the learned friend is right that Section 10 applies, then in any event, I say, there's no causative link that's been shown, and the clause, whether you regard it as 3 or 3 with 2, is of no effect to that extent.
Well, I think you need to deal with them separately, don't you, because they are advanced separately. So what's the argument on causation in respect to 2? Because that's not a best endeavours obligation, that's an absolute requirement to contract on, in this case, FSDF terms.
Yes, if one looks at that on its own, and it doesn't mean what my learned friend says it means, then my submission in relation to that is that it's purely the other end of the representation. It's an automatic consequence of that representation not being correct.
No, I understand that, but I'm looking now at the argument put against you that even if you're right on all of this in terms of that it's disadvantageous,
yes,
it's only disregarded to the extent that it goes beyond or allows the insurer to go beyond what they would otherwise be entitled to under Section 10
I accept.
and 11.
Yeah, exactly.
And
under 11.
Yeah, and how is that? How do you? They say it doesn't. So how do you deal with that argument?
No, I accept that in relation to 2 on its own,
Right.
if the breach that you identify is non-declaration of a particular policy, then I accept that must be necessarily related.
Well, no, it's the breach is not. And this is taking the other side's case. It's
Yeah.
not non-declaration. It's the breach is not trading on those terms.
Yes.
Or trading on other terms.
Yes.
You'd say the same thing, I think, wouldn't you, in terms of causation?
Yeah, I would say the same thing, although I would agree with my learned friend when he says that even if the SDF terms applied, it wouldn't relieve the insurance from all liability. In any event, the insurer would have liability, which is the liability found by the judge, namely liability, the time bar would only apply to the first 6 pallets. Sorry, would apply to the first 6 pallets, and there would be a reduction in the limit down to £250 a ton. So still would be liability.
I think it's per kilogram.
But it would be a reduced liability, I say
a reduced liability rate based on the calculation of the money cap and the pallets that fell within the time bar.
Exactly. Well, unless I can assist you further, those are my submissions.
I've just got two questions. They're just confirmatory. They're not, and I'm asking you them now just so that Mr. Buckingham can hear and he can tell me his answer to them as well. They're very, very basic. LMA 5264. From my researches, LMA is Lloyd's Market Association, and that is one of their model clauses which they draft, which is available for incorporation.
Exactly.
Is that right?
That's absolutely right.
And when you were taking us through the policy and making your submissions on the wording, both for inception of the policy and currency of the policy, you went to the passage which actually is headed period, but I'm sure it's common ground, but just confirmatory again. Inception of the policy is the beginning of the period.
Indeed.
The currency of the policy means the period.
Absolutely.
Yeah. Right. I'm sure, Mr. Buckingham, neither of those you quibble with in terms of answers, but if you do, you know, it's a chance to tell me they're wrong.
Well, Lord, I don't.
No, thank you very much.
Thank you very much.
Mr. Warner. Yes, Mr. Buckingham, anything in reply?
Lord, just two topics. So I'm conscious you've heard from me at length on construction, so although I will come back to that, I'll do so shortly. But if I can start with the question of transparency. And as you'll understand, we don't suggest that the particular steps required by Section 17 were accomplished. Our point is that under Section 16(2) of the Act, there is no disadvantageous term, so one doesn't get into Section 17. And that's true in relation to both some clauses 2 and 3. And can I just approach that by reference, firstly, to the effect of the statute, and then secondly, by reference to the effect of the wraparound clause, to which Lord Justice Fraser just referred. First of all, by reference to the statute, and just to orientate the argument, as I understand it, the particular provision in the policy to which exception is made is the one on page 138 by the first hold branch, that the effect of a breach of condition precedent is that underwriters are entitled to avoid the claim in its entirety. And of course, the duty of assured clause itself doesn't contain any sanction for breach. One has to look here on page 138 for the sanction. And the complaint, as I understand it, is that entitlement to avoid the claim in its entirety goes beyond Section 10, subsection 2 and Section 11, because it's not limited to breaches of warranty which have not been remedied, and it's not limited to situations where there's some causation. And my submission, the answer to that, firstly looking at the statute, and it's Section 16, subsection 2, I can take your lordships back one more time to that provision in the authorities bundle at page 48. And I think, in fact, the point may have already been raised in argument by Lord Justice Zacaroli, that what 16(2) provides, if it's engaged, is if there is a term which is disadvantageous, then to the extent it's disadvantageous, it's of no effect. And as I took pains to show your lordships before the short adjournment, in this case, the breach of warranty under sections 10 and 11 would entitle the insurers to decline the claim.
The whole claim, not merely to the extent that it can show causation. As in, not just to the extent that the loss flowed from the particular breach. It can avoid the claim entirely, you say?
Yes.
Yeah.
So that is the short, or the first short answer
Mm-hmm.
to the transparency point. And then the second short answer, and I say that with some trepidation, because I come back to the LMA clause, which I perhaps didn't show your lordships before the short adjournment with the proper detail. And it's, if I can ask your lordship to turn it up, it's behind tab 12, starting at page 141.
Mm-hmm.
And I showed you that the general clauses, 1, 2, 3 on page 141. But then if one looks on page 142 at paragraph 7 and 8, and this clause, this whole document, of course, is incorporated into the contract. And clauses 7 and 8 provide for the same protection one sees in sections 10 and 11 of the Insurance Act. So you have spelled out as a matter of contractual language the same degree of protection, and therefore the same degree of liability in any particular case as you would get under the Act. So in my submission, these two clauses...
I'm still struggling as to why that makes any difference.
Well, it may not, and given the first point it made, it may not. But
I understand. But as a model clause, which is obviously intended, can be incorporated either by reference or expressly, because there are square brackets under critical information for condition precedents, if there are criminal convictions, for example, things like that. It puts in, well, it puts in slightly different language in some places the main operative provisions of the Act. That's what it does.
it does.
Yeah.
As a matter of contract.
Yeah, I understand.
So that is all I wanted to say about transparency.
Mm-hmm.
And we're just coming back to the fundamental question of construction. And in the course of arguments, the observation I would have is that this does appear to be an appeal that turns more upon the proper construction of the policy rather than the operation of the Act. But there it is. And the first point we would make is that it would be a slightly strange result if the outcome was that the insurers were unable to restrict the scope of cover under the policy to liability in relation to trading in accordance with declared and approved terms, which would be the effect of the construction which my learned friend advances. I didn't submit, I certainly didn't mean to submit at any stage that subclause 2 and subclause 3 mean the same thing. In my submission, that they don't, and I took your lordships through that. But as regards my learned friend's suggested construction, the starting point is that on the face of the policy, one does have stated the FSDF terms, and his construction fails to give any effect to that clear statement on page 1. And as I said before the short adjournment, the significance of that statement is that represents the declared and approved terms. It tells you what those terms are. And that is an important starting point for any process of construction. As is what I have called the scope of cover clause, which says in terms that the cover is in relation to liability in accordance with, and then it sets out, it's true, a number of different standard clauses or the assured own trading conditions or other conditions. And my submission, as your lordships heard before the short adjournment, is that the requirement for declaration and approval relates to all of them. So what will happen in practice is that the assured will say, these are the conditions that I'm trading on, and let's suppose it's Aqua and FSDF, to take an example. and the insurer has then the decision whether to approve trading on those terms. And here we see what happened, was that the FSDF terms were declared, and it was those terms which were approved. Now even if that's right, if that's wrong, and it's open to the assured to trade under any of the terms listed in the scope of cover clause, then on the facts of this case, that doesn't assist the assured because there's no suggestion that the Scotbeef contract was on any of those other terms, or on any view it was a contract on terms which were not declared and approved. And as I submitted, subclause 2 applies, we say, it means what it says in our submission. The assured continuously trades under the conditions declared and approved. And that makes perfect commercial sense in the context of the page 1 of the policy and the scope of cover clause. Whereas the consequence of learned friends argument is that the assured can misdeclare the terms on which it's trading, continue to trade on those terms which haven't been declared, and be covered for that, and not be in breach of clause 2, and be covered for that. And my submission that is simply that would be a very uncommercial result, and it's very unlikely something that the parties could ever have intended. And our construction gives rise to a scheme which gives due weight and account to all the different aspects of the policy, which I've shown you, Lordships. And I would commend that construction to you, Lordships.
Yeah.
Lords, those were only the only 2 points, unless I can insist on anything else.
No, thank you very much.
Can I express my ironic disappointment that neither of you took us to the 1812 statute, which is in the authorities book?
Well, it's not too late.
No, because if you had, I had one from 1786, which I was going to mention to you, so perhaps it's best you didn't.
I agree and have nothing to add, as we say in this court. Right, thank you both very much, and thank you to those sitting behind you who knew that a few lorry loads of mouldy meat would give rise to some quite interesting and difficult issues. You won't therefore be surprised to learn we're not going to embark on extemporary judgments this afternoon. We'll reserve our judgments in the usual way. The process will be this: as you both know, you will receive draft judgments from us. That is an opportunity for you to correct the typos and the grammar, but it is not an opportunity to re-argue the case. The draft will go to the people on the list that my clerk has prepared, the email list that my clerk has prepared. It's not to go to anybody else. And as you both know, there are sanctions for those who breach that embargo. So it is only to be seen by those on the list. When you return your typos and grammatical errors, at the same time, we hope that you will have discussed between you the appropriate order to reflect our judgments, and if possible, you can provide a draft agreed order at the same time as the list of typos. If you can't agree any aspect of the order, then the course to adopt is to produce each of you very, very short written submissions about the points of difference, setting out what you say, and we'll decide those on paper, so that you will then receive our decision on those points, so that you can then, on that basis, draw up an agreed order. and the judgment will then be handed down, and it will be handed down electronically, so there's no need for any attendance. I think that deals with everything. Thank you very much.